Hello and welcome to this episode on management and administration of companies under the Companies Act 2013. To discuss this issue, we have the benefit of the company of Ms. Savitri Parekh, who is the Chief Legal and Secretarial in Pidilite Industries, and Lalit Kumar, Partner JSA, a national law firm. Can I just begin by asking, can you give us an overview of the manner in which company meetings would have to be held and administered? How does the Act deal with the management and administration side of meetings in general, in particular general meetings and also board meetings to the extent you can touch upon that?
Talking of general meetings, the two main aspects are with respect to convening of a meeting of members and conduct of the meeting. So when you're referring to convening a meeting of the members, notice needs to be given adequately in advance. You need to give at least 21 clear days of 21 clear days notice of any general meeting. You also need to give explanatory statement which would enable the members to consider the item of business which needs to be transacted at the general meeting. The law protects this and has provisions clearly governing these. About conduct of meetings, the chairman will conduct the meeting based on the agenda which has been circulated to the members. It's also necessary to confirm compliance with the provisions of law, where now under the Companies Act 2013, a report is required to be filed by every listed company confirming compliance of the provisions of Companies Act 2013 with respect to convening of the meeting as well as conduct of the meeting.
Right. Would you like to supplement some of?
Also, when notice is given, and there are provisions when you have to have shorter meetings at shorter notice, so there are adequate provisions. 95% of the shareholders can agree and give their consent that 21 clear days notice is long, we want to do the business now. So there are provisions for that. Additionally, e-voting provisions have been introduced. Then voting can be done through electronic voting. Then postal ballot, which is also one way of voting, and it is encouraged much more that all the papers go to the shareholders, they sit at their place and then they vote from there. So in terms of the voting requirements, in terms of the meeting of the shareholders, so this is as she said about explanatory statement also about
Right.
We have to give
We've actually
additional
had
contents.
another episode on transparency and disclosures where we've spoken about the law on contents of an explanatory statement and how quality of an informed decision by shareholders has been improved. But can I move this slightly to a different theme, which to my mind would be formulated something like, how does the Companies Act 2013 deal with the sovereignty of shareholders as a forum vis-a-vis the powers of the board? What's the balance between powers of the board in terms of the absolute right to run a company the way they choose once appointed by shareholders, and what are the checks and balances that shareholders have over the decisions of the board? When does the board have to go to the shareholders, and what threshold of support do they need from shareholders?
Sure. Section 179 is very specific, which says that all the powers of the company will be vested with the board. The board will exercise those powers, act in the interest of the company. In the same section, there are certain business items which are listed, which can only be done by the meeting of the board of directors, which means that those matters cannot go to the board of directors through circulation. So that gives the importance to the board's decision-making power, which is well codified in section 179. But there are certain instances which are listed in section 180, which restricts the power of the board. Certain businesses which the board of directors cannot do until and unless they have the blessings of the shareholders, and the blessings of the shareholders have to be by special resolution. For instance, when the company wants to sell its undertaking, when the company wants to borrow exceeding its net worth, there are certain instances listed in that section. So shareholders vote is essential, and the board has to go to the shareholders.
So if shareholders approve by a special resolution, a company could borrow more than its own net worth.
That's right.
Of course, provided someone's willing to lend the money, but You don't need to go to government for these approvals.
No, that's right. So shareholders have been given the power. In fact, from the 1956 Act, this power, which was by an ordinary resolution, has been made a little stricter. It has changed it to special resolution, 3/4 majority of the shareholders.
Typically, the resolutions of the board are passed by taking approval of the majority of directors. There are certain matters which would require unanimous consent of the directors. Just to give an example, if a person is already a managerial personnel in any other entity, in any other company, then consent of all the directors would be required before appointing such a person as a managerial personnel in this company. The board can exercise its powers and pass resolutions either at a meeting of the board of directors, which has been validly convened, or by passing a resolution by circulation. But as was explained by Lalit, there are certain items which cannot be passed by passing a circular resolution. Some of the items which can be passed by passing a circular resolution is convening a general meeting. You may want an extraordinary general meeting to be convened. The resolution approving convening of a general meeting can be passed by circulation. But the item which is required to be considered at the general meeting may require approval of the board, which could only be given if it is a validly convened board meeting. Like say for example, if it's with respect to borrowing, you would need to have a board meeting at which this item is approved. Maybe you pass a resolution by circulation for fixing the date on which the general meeting would be convened.
So I suppose the legislative intent is to exploit the power of deliberation.
Absolutely.
That if you actually, when you engage and present conflicting ideas and reconcile conflicting views, that quality of discourse needs to be undertaken before those decisions in 179 which specify a meeting. That's the intent of that law.
Absolutely. In fact, just to take the same point a little further, the distinction between items which require deliberation and hence more detailed board note has been distinguished from items which require approval and which approval does not require discussion among the board members. So a substantive issue needs to be placed before a board at a board meeting, while procedural issues of date on which the general meeting can be convened, just to quote an example, can be passed by circulation.
Right. Let me just pause here and ask a question. This is of course without prejudice to a company's right to raise the bar.
Sure.
And say that more than the items listed in 179, other items too will need a meeting.
Certainly.
The company is free to have its articles say that.
Absolutely.
Right.
Just to also add, there's a very interesting provision, and for the first time introduced, is in section 5 about retrenchment provisions in the articles. What it says is that the company can list out certain articles, certain clauses in the articles which can have a stricter approving standard, which could mean that even the law provides for a special resolution, but company writes in the articles, certain articles will require a 90% vote. It will be voted by 90%. So they have left it to the company's management, company's shareholders to decide what articles and what clauses in the articles are so important that they need a higher threshold than even provided in the law. So this retrenchment provision is an important and a new concept given in section 5.
Right. Another interesting dimension, that if you raise the bar for a resolution to a certain threshold, whereby unless a certain shareholder who holds a minimum threshold approves, you will never pass that resolution. What does that mean under the Companies Act? Would that bring that person within the ambit of a promoter by having control? These are issues that could arise?
Well, yes, it certainly could arise with respect to definition of the term promoter. But taking a slightly different point on this particular question, in fact, the provisions of joint venture agreements or shareholder agreements, especially with foreign entities, have now been given legal sanctity in the sense that although they may be more stringent, they can be read into the governance of companies, and that's the way the company would be managed, although it's more strict in comparison to the provisions of the law.
Right.
I think there is nothing very specific, Som, in this about when you give a right to a shareholder or like a affirmative right or a veto right. So those concepts are still not provided. What will happen in that situation in respect of that shareholder, whether that shareholder will be in control of the company? Yes, of course, if judicial precedents support and if meets the test of control given in the Companies Act, there could be, but
It
this
will
is
always remain a
remain
question of fact in
that's
each
right.
case.
Interpretation,
That's right.
yeah.
That's right. So there's much excitement lying in store, even now under the Companies Act, on these issues. Can we talk a bit about quorum and what are quorum requirements in general meetings, board meetings? What are those decisions which cannot be, what is the law on quorum, and can a company prescribe a quorum superior to what the Act provides for?
Sure. Quorum earlier was a fixed number of just 5 members to be personally present, but now there is a slab depending on the number of members that the company has on the date of the general meeting, referring to general meetings. Say if the company has less than 1,000 shareholders, then 5 members personally present would be quorum. If the company has more than 1,000 but less than 5,000 members, 15 members personally present would be quorum. And if it has more than 5,000 members, then 30 members personally present would be quorum. This is a marked deviation from the earlier Act.
And you think this qualitatively sort of regulates the quality of participation in a decision, or?
It certainly enhances the participation of the members, and to that extent, yes, I think it is a welcome change.
Right.
And interestingly, even as you said, the Articles of Association can even prescribe higher quorum in the general meeting. Similarly, for the board, it will be 2 directors present or 1/3 of the strength of the board, whichever is higher. The interesting point here is that while they have very specifically provided in the Companies Act 2013 with respect to can quorum be formed if a member is participating through video conferencing.
Right.
For the board meetings, there's a specific provision which says this, that members participating through board meeting video conferencing will also form quorum. For the general body meeting, they still specify personally present.
Right.
So the first, there has to be a person as was mentioned, the quorum. Physical and personal present will form the quorum, and then other members can participate through video conferencing also.
Right. So the liberalization for board meetings about the capacity to participate despite physically being away is not available for a general meeting. Can we talk a little more with some practical experience about reform on the aspect of convening these physical meetings and some moves in the Companies Act 2013 to make commercial life simpler, to be able to hold meetings more possibly feasible?
Sure. One of the main changes I would refer to is with respect to a day on which a general meeting can be convened. The earlier Act provided for a holding of a general meeting on any day which is not a public holiday. In fact, it said it could be held during business hours on any working day. So this definitely meant that you could not hold a general meeting on a public holiday. Now the list of public holidays in India is reasonably long, because any holiday which is declared under the Negotiable Instruments Act becomes a public holiday. But under the Companies Act 2013, the exclusion is only with respect to national holidays, and there are only 3 national holidays in our country: Independence Day, Republic Day, and 2nd of October.
Right.
So there's a lot of certainty which has now been brought in, and the meeting can be held during working hours right up to 6 o'clock. So which actually means you can convene a general meeting on a Sunday too.
Right.
And therefore, certainty of holding a meeting, a general meeting on a particular day, has been brought in.
So you could even
In
hold
fact,
a meeting on Diwali or Christmas
absolutely.
or Guru Nanak Jayanti or
Yes, absolutely.
right.
Yeah. In fact, I'm reminded of one incident which, of course, happened many years ago, almost about 13 years ago, when Mother Teresa passed away. The day of her, the day she was to be, the rites were to be performed, was declared a public holiday. And this was in September. If I remember right, it was around 13 September or so. And this was during peak AGM season. And most of the companies were worried about holding the AGM on that particular day. So I think these kind of issues get handled in a much more simpler fashion now, with the Act being very certain.
Right. But one of the issues about not being able to do a video general meeting is that the meeting would have to be held in the place where the registered office is, and therefore one would have to go to that town to physically attend a meeting.
Absolutely.
That remains a challenge in Indian law.
Yes.
Right. Especially when the registered offices are in a remote places where the access to the common public shareholder is not available. So there still would be a
Right.
challenge.
As a parallel process, that of course gets dealt with by postal ballot as a means. So if you could throw some light on postal ballot, and are there areas where postal ballot is mandatory in the Act, and can you voluntarily do everything by postal ballot? Can you throw some light on
Specific
that
section has been provided for postal ballot. So listed company, there will be a list of certain businesses which central government will prescribe. They will have to be through postal ballot. And then what they have said, in certain businesses, ordinary businesses, cannot be done through postal ballot. And businesses where the presence of director or auditor is necessary, they have reserved that those cannot be done through postal ballots. Otherwise, a mandatory requirement would be on all those businesses which the central government would prescribe for listed companies will have to be through postal ballot. Other companies can choose to do businesses through postal ballot, with the exception of the ordinary businesses and business in the meeting where you need the auditor or the director. So that's the requirement of postal ballot now.
Right. The other area I thought we could touch upon in this context is approaching the whole scheme of the provisions, but from a different angle. Can we talk about difference in perspective in the Act, in how it deals with public companies, private companies, and listed public companies in the arena of management and administration?
See, earlier, private companies enjoyed a lot of exemptions. Just to quote an example, if the company wanted to sell or lease its undertaking, the provisions of Section 293, the earlier Section 293 under Companies Act 1956, was not applicable to private companies. But under the Companies Act 2013, even a private company will need to pass a special resolution for sale of its undertaking or for borrowing beyond its paid up capital and reserves and free reserves. So with respect to management, there is a little more of accountability. Of course, with respect to quorum, in case of a private company, the quorum provisions remain just the same. 2 members personally present would form quorum. But with respect to management, yes, the exemptions which private companies earlier enjoyed the list has got truncated now.
Right. So would it be fair to say that the hurdle has been raised, the bar has been raised for quality of governance in private companies?
Yes, it would be right to say
That's
that.
right, because it's moved really for private companies from being self-regulated to be regulated now.
Right.
So a lot of exemptions which were there have been taken away. Some exemptions are still there, like rotation of directors, when you are rotating directors at the annual general meeting. So those directors in public company have certain proportion, have to rotate every year. That provision is still exempted for private companies.
Right.
Just to make a difference between a provision which is for a listed company but which doesn't apply even to an unlisted public companies, in situation where a report now has to be filed with the registrar of companies by a listed company saying all the provisions with respect to the annual general meeting were duly followed, adhered to, and all the compliance with respect to AGM was done. So the listed company has to do that, but an unlisted public company or a private company is exempted even now.
Right. So would it be fair to say that the thinking in Parliament, the intent of Parliament is that ultimately as a corporate body, you play a significant role in society. Whether you're private or public, doesn't matter. You're the ones who are taking loans. The loans are taken from banks. Banks in turn take money from public depositors. So even if you're private, if the quality of your accounts, for example, is horrible, you do have a social impact. And therefore, raise the bar regardless of whether you're private or public. Would that be a fair theme or intent of how to read these provisions?
Yes, I would agree with you. I think that's a fair interpretation.
Right. So whether you're private or public, for purposes of Companies Act, doesn't matter. That you are in any case playing an almost similar role vis-a-vis other stakeholders doesn't have an impact, and yet there is a differential between the norms for listed public companies or listed and unlisted public companies. So a different sort of gearing through the scheme of the Act has been done, and I would think that our viewers would have to then read a lot of provisions and see the entire scheme of the Act
Sure.
to internalize the new reality.
That's right. Also, just to add here, Som, there's a specific section 462 which has been introduced, which still gives power to the central government to keep exempting certain companies or certain classes of companies from certain provisions of the Companies Act 2013. Maybe it's too early to say. Maybe in time to come, some exemptions are brought back for private companies through the central government power of 462. But as the things stand today in the law which is we have today, is a lot of exemptions have gone from private companies.
So would you say that you mentioned a bit about the report of the meeting to be filed with the ROC by listed companies? What does this do? What sort of report is it? Can you elaborate a bit on the nature of this new measure?
There's a specific section which has been introduced, section 121, which requires all the listed companies to file a report of the annual general meeting, which confirms that the meeting was convened, held and conducted as per the provisions of this Act. And this has to be 5-star of companies within 30 days of the conclusion of the annual general meeting. The form of the report will be in terms of the draft rules. What will be the form look like? And this has been done just to ensure that after the meeting is conducted or concluded, everything which is with respect to the annual general meeting, whether time when it was held, whether it was during the meeting the quorum was present, whether all businesses as they were supposed to be taken were taken, so that because annual general meeting is perhaps the most important meeting of shareholders.
Right.
The annual, every year it happens. So perhaps the laws, intention of the law here is that the conduct of annual general meeting has to correctly happen as per
Right.
the laws, which is why this kind of report
So
has
you have
been
to put pen
introduced.
to paper, check the box and say, I've done each of these.
That's right. That's right.
Right. Which takes us to another issue of what are the standards to be followed in the management and administration of a company. It's one thing for substantial law, and a lot of the provisions I see are principles-based law. In terms of you shall do good, you shall exercise due skill and care, you shall be diligent, you shall take into account stakeholders' interests, etc. But to get these principles actuated, you would need a norm,
Sure.
a minimum norm or a bright line test to be met. So could you throw some light on standards
Sure.
and what are the standards before this law became law, and what sort of change in the dimension of this aspect of the law is?
Sure. The Institute of Company Secretaries of India has already come out with 10 secretarial standards on different issues and different topics. The most important one being on meetings, general meetings, board meetings, passing of resolution by circulation, dividend, and so on. Earlier, when the Institute issued these guidelines, they were not mandatory. They were more in the form of guidance notes and more in the form of good practices. But now, under Companies Act 2013, these secretarial standards have become mandatory, and the central government would be notifying, and once it is notified by the central government, these secretarial standards would need to be adhered to. Of course, some of these secretarial standards would need to be revised to bring it in line with the provisions of 2013 Act, but most of them, since they are procedural laws, have been very correctly drafted, bringing in the spirit of the law rather than just the letter of the law. And the practices have been well documented in these secretarial standards. Talking about the compliance report, when a confirmatory report is given confirming compliance, it's the secretarial standards which would be heavily relied on.
So can I take this to another level in terms of, it's great to have standards, it's great to have principles which outline the legislative intent, but what happens when a standard is breached? There is a provision which says when no separate penalty is provided, there would be a certain penalty and you can adjudicate through an adjudicating officer. So do you see this to become an area of a lot of enforcement activity, where there could be proceedings either against a company or against the company secretary for not ensuring that the company adheres to standards? What are your thoughts on?
Sure. I think there are two specific aspects here. To begin with, the compliance certificate issued by a company secretary in practice, which is issued with respect to listed companies, would clearly show the cases where 100% compliance has not been ensured. Secretarial standards again would have two specific heads. Ones which are required to be complied with in toto, and second which are recommendatory. Where one is not complied with the ones which are recommendatory, of course it's just a reflection on the practices, but one where it is mandatorily required to be complied with, yes, of course over a period of time may come up as enforcement actions, but in the near future I don't see them as being taken up by the authorities, because it would be more in the form of looking at the practices and the compliance report of the company secretary in practice, clearly reflecting the areas where it is not in compliance. So it will be more in the nature of a qualified report. And if it's a qualified report, the director's report will also need to address the specific issues.
Right.
So it will be more in the form of a burden on the directors of the company to explain. It's more as a what if provision than an absolute compliance.
And life is always complex. There'll never be 100%. I mean, you should rather be wary of the guys who say they're 100% compliant in all respects, and you'd rather trust somebody who says I was 99% compliant.
Absolutely.
1% could not be done because of the following reasons.
Absolutely, and also law cannot be absolutely a straitjacket piece of legislation.
So is there any other aspect relating to management and administration that you'd like to broadly touch upon and perhaps summarize your thoughts, either thematically or specifically, in terms of what the Act of 2013 does in this space?
Let me also, going forward with the electronic voting, one is the role of electronic media and electronic form has been accepted as a very important media. Now, minutes, there were always questions whether minutes of the meeting, whether the registers, the statutory registers could be maintained in electronic form, in software, or they have to be necessarily in physical form. So there's a very specific clarification in a section which says registers, minutes can now be kept in electronic form. So the companies who face maintaining registers and bulky registers in physical form can just have them on the system, and they will
secure electronic records under the Information Technology Act.
That's right. That's right. So I would say that this is also one of the important things when it comes to maintaining registers and administering the records of the company. Other thing is, which I think is more to do with the related party, unique concept of interested shareholders will not vote. So that whenever a matter comes up in the general meeting or of the shareholders, so they have to abstain from voting. But that's more to do with the related party and case specific.
That is
also, extracts of records can be given in an electronic form. So even in email correspondence, would be recognized as sufficient compliance.
Right. So then gone are the days where you have to say, if left at the address of the registered office, then it's sufficient compliance.
Yes,
We're moving away from that sort of an era.
absolutely. To some extent, it then becomes paperless.
Right. Tell me, what does all this mean for yet another dimension that suddenly occurs to me? What does this mean for diligence of companies? How tough or easy is it going to be under the Companies Act 2013 to know what a company has done, has been doing, and how well it's been doing it from public records? And feel free to differentiate between listed, unlisted, public, private, the way you want to give a differentiation.
Sure.
I think it's a mixed question of management and administration and the disclosures. So disclosures have been enhanced. So if you look from a stakeholder's perspective, what all goes to the registrar of companies? We just discussed about a report of the annual general meeting goes to the registrar of companies, which is a public office for records to be seen. So not only in management and administration, not only the rights of inspection, not only the rights by postal ballot, electronic voting, in my view, this will be much more wider participation of the stakeholders in the company. Just to give one more example, now notices of even annual general meeting, they have to be given to directors, which they were given in any case, but now there's a specific
Right.
provision which says that the director is entitled to get the notice of the annual general meeting. So keeping every stakeholder's interest in mind and keeping the enhanced disclosures and the new things that have been introduced, I would say that the level of awareness, the level of participation, level of access to the documents which the company has, which will be much higher now, and which is a good step.
I think the appetite for information which a shareholder would have is reasonably well met under Companies Act 2013. In fact, there's a provision which also requires the companies to file details of top 10 shareholders within
15 days of it.
and then
Promoters
there's any
and top
change-
10 shareholders.
Absolutely. So if there's any change in the shareholding, even the change is required to be filed with the registrar of companies within 15 days of change.
Right.
So in terms of appetite for information, I think it's all there, and the MCA website is going to have all these details.
So good, I think that's a very useful and comprehensive summary of various things, but needless to add, I mean, this is an area that's so widespread. It's spread across various chapters and sections that as company secretaries, one will have to actually pick up these provisions and read them and connect the dots and imbibe from them as to what are the various conditionalities and ingredients of the law that need to be met in the management and administration of companies in India, regardless of whether they are private companies or public companies or listed public companies. We strongly encourage and urge you to look up the provisions of the Act. These primer videos are meant to be an overview to give you a broad idea of important aspects of the Act. Please do look up the provisions of the Act. Thank you very much. Thank you.